Yeah.
On the front cover.
Yeah, there it is.
Board members, we're here for the board meeting today, and Freddie Black, the chairman, was carrying over, but he is out of town. So before we get started, you all will need to elect a temporary chair for this meeting to lead the meeting.
I nominate Alex.
I'll second it.
Done.
Okay,
So Alex, if you want to move.
I'll get in the middle chair. All right.
Yes, you get to move to the chairman's
Wow.
chair, and Start the meeting. if you would like, we can take it.
Okay, so I'm gonna do that at the end.
You need to start off, right, after you start the meeting, you need to read that for your per diem, unless y'all don't want to get paid.
Okay, yes, I'm gonna agree with you when it's actually here. When votes right there. Good morning, I'd like to call this meeting to order. Starting with our director's decisions, violation resumes, warning letters, and inactive status letters. And do you want me to read this before that?
If you would.
Okay, before that, in accordance with Act 1211 of 1995, as amended, the Alcohol Beverage Control Board did as its regular meeting held on January 18th, 2023, unanimously vote to continue to reimburse themselves for mileage and hotel expenses incurred while performing their official board duties. Further, the board unanimously voted to continue their per diem at a rate of $60 per day for each meeting, examination, evaluation, or inspection attended or for any day while performing any proper businesses of the board, dated this 18th day of January 2023.
You'll need to vote to accept that.
I move we accept the what was that?
This is Act 1211, 1995.
I'll second it.
All in favor?
Aye.
Michael, you give a look, so.
It passed.
Yes, so the motion passes. Next on our agenda, we'll start with the director's decisions, violation resumes, warning letters, and inactive status letters.
I'll make a motion that we approve the director's decisions, violation resume, warning letters, and inactive status letters.
I'll second.
All in favor?
Aye.
Motion carries. Director, do you have anything else for us this morning?
Now, I believe all we have is set for the next board meeting before we go into hearings. February 15th at 9 a.m.
Should work for me. Steve, that work for you?
Yes.
Okay, good. All right, we'll set that for our next board meeting, February 15th. Director, is there anything else from you all at this point?
I have nothing.
Okay. If that's the case, then we'll start with our first hearing of Marco Santana, the Ranchito Bar and Grill of Arkadelphia, located at 2805 Pine Street, Arkadelphia. Rick's Restaurant Mixed Drink New refused on December 22nd, 2022. Applicant does not meet the residency requirements by living in the same county as the proposed business or live within 35 miles of the proposed premise.
Okay, I'm gonna pass out a couple of exhibits that I have. This one.
Is anyone here for the first hearing?
The first exhibit that I passed out is the actual director's decision. The second exhibit I'm passing out is a copy of the letter that was mailed to him and proof of receipt of that letter, setting the date of this hearing to establish service of the notice of hearing.
It looks like we've updated the time to say 9 o'clock versus 9:15. Yeah, it used to say 9:15.
We changed that so that we can roll straight into hearings.
Perfect. Director, do you want us to give a few minutes? Doesn't look like they've arrived here.
I think we can go ahead and start with Michael being on his proof, since we have proof of service that he was served with a 9 o'clock start time.
Okay.
Yeah.
Michael, go ahead and then.
Yeah, the first exhibit that I passed out, like I said, is the director's packet. I would ask that that be admitted as ABC's Exhibit 1. The second packet, as I indicated, is the proof of service indicating that it was served on the applicant. I'd like to ask that that be admitted as ABC's Exhibit 2.
Granted.
Okay, and at this time, I would also ask that we have Agent John Ferguson, who's here from ABC Enforcement, to sound the hall for Mr. Marco Santana. You can sound the hall for Marco Santana. Marco Santana.
Doesn't appear to be anybody in the hallway.
Okay.
Please state your name for the record.
John Ferguson?
Okay, and you just sounded the hall correctly, correct?
I did.
Okay, no one was present?
They were on it.
Okay, let the court be advised that there's no one here. You've got the director's decision in front of you, and services proper on the applicant. We would ask that the appeal be dismissed for not being here to prosecute it.
I'll make a motion that we dismiss the appeal and uphold the director's decision due to the fact that we have no new evidence of any change of address or distance from the facility. And I'll second that.
Okay, all in favor?
Aye.
Motion carries. The appeal of the Ranchito Bar and Grill is hereby dismissed.
Thank you.
Thank you, Michael. Michael, as a point of procedure, it looks like the next two cases seem to be the same applicant. Will those be done together or treated separately?
I'm going to defer to Mr. Lakovich on that. I believe those are medical marijuana hearings.
Okay,
So those are actually two different permits.
Okay. so we'll treat them separately. Okay. Do you want me to sign this? Or is that- Okay. Okay, I didn't know that. Morning.
Morning.
Good morning.
Morning.
Distribute the package from ABC.
Maybe.
You want us to distribute ours at the beginning?
Like to.
Do we need to accept this back first?
I'll make a motion at the conclusion of ADC's case to introduce them. The agents will be referencing the page numbers throughout. As you see, there's also some ABC rules and if it meets the pleasure of the board, I'll go through the procedural aspects of this case and just how we got to this point.
Okay.
We need to swear people in first.
Well, are these the attorneys?
Yes.
We are,
Okay,
yes.
so,
Are you-
Right there.
I'm sure you woke up today and said, I want a bunch of paper, right? They're good.
because they're not making.
Yeah, we want.
Okay.
How are you?
I'm good.
Did you know you were gonna be chairman this
No, I found out a few minutes ago, so I'm very on the phone.
morning?
We need to make a motion to accept their,
Oh, I guess. They want to add that in.
go ahead.
Members of the board, on June 3rd, 2022, there was a notice of hearing sent to Alex Gray, the permit holder for Burgers by Good Day Farm Dispensary here in Little Rock. The allegations were that on April 15, 2022, the facility advertised and marketed medical cannabis with none of the required disclosure statements, which is a violation of ABC Medical Marijuana Oversight Rule 19.1B2 and Arkansas Code Annotated 2056-305B2, 2 counts. On April 15, 2022, the facility caused advertising for medical cannabis to be placed on publicly owned property, in violation of ABC Medical Marijuana Oversight Rule 19.1B4C. And that on April 15, 2022, the facility had improper signage advertising, which is a violation of ABC Medical Marijuana Rules 19.1 and 2. The director's hearing was held on August 24th, 2022. At the conclusion of the hearing, the facility was giving a warning relating to a tent that they had at the facility due to their prompt removal of the tent. And that also dispensed one of the violations of the first count of our ABC Medical Marijuana Oversight Rule 19.1B, that one at the top and that one at the bottom. So 2 counts were reduced to warning as a result of that order. Permittee timely filed notice of appeal of that matter. Ultimately, as you see, this was set for hearing today. Which brings us up to where we are now. So we have those 2 counts before us today. And the board would make it your pleasure to swear in those witnesses.
Sure. Can you please have your witnesses come forward? Can you please raise your right hand? Do you swear the whole truth and nothing but the truth, so help you God?
I swear.
Okay, thank you.
May I proceed?
Absolutely.
Go ahead, state your name for the record.
I am Austin Hodges. I've been with ABC Enforcement since November of 2020.
Okay, and were you so employed back on April 15th, 2022?
I was.
All right. This was sent to us initially by a report that was authored by you. So can you tell the board what it was that led you to that day?
Yes, I can. So on April 14th, I received a text message from Audit Manager Personal. He had received some information regarding a bus that was parked in front of Africa Bank. He sent me an image of the bus, which showed that it was light blue in color and had cookies on the side. And was parked in the great area Africa Bank. On April 15th, I began looking for that bus and was unable to locate it here in Africa. By Good Day Farm, where I located that tent that was set up along with a large group of people. It appeared they were having some type of events that day. At that time, I didn't see the bus there, but then when I came back a little bit later, after going to search through other spots, I did locate the bus behind near the delivery area. I was able to photograph the bus behind the dispensary and show that it had cookies on the side, that it was visible from the roadway. And that the coloring matched the same coloring of the dispensary.
Page 9, just let me put a pause real quick on that. So in this exhibit packet that was produced, we have this image here, page number is kind of fading, but page 8 of this packet. We see a bus with cookies, it's a blue bus. That was one of the images that you took that day.
That is,
We have the next page, same bus with cookies apparently on the side. Is that correct?
that is correct.
And then we have the dispensary here. That's the blue building.
That is correct.
And kind of walk me through the remainder of these images. This one,
So these photos were actually taken after the bus was moved. So I made contact with Director Potter, who was able to reach out to the company, and they agreed to take down the tent and move the bus to the location. It was moved to a business that is directly behind the dispensary called East Florida, to their parking lot. From there, I will get more images of the bus. That includes the next image, which shows Cookies along the back, Cookies Co. below it, and a license plate out of California that displays 8MEE817. I then took another photo of the back. It shows the same thing, along with where it's kind of located in the East Fork parking lot. A photo of the side, it shows Cookies on the side along with lemonade. The shape written in the shape of lemon in yellow and green. Or the leaves are green, the writing's in yellow. The lemonade is one of the product lines for Cookies. I took a photo of the front that shows the Cookies emblem on it. Yeah, that's all. Yes, that's all.
okay. Now this emblem also appears on the dispensary burners by Good Day Farm.
It does.
Where is it on the dispensary?
So if you go back to the photo that shows the bus and that, you can see that there is the blue building is kind of set up. It's along the sides here at the top of that building, not quite at that very tip right there, but about there, and it's on both sides, one facing the main roadway and one facing the township.
That same Cookies logo.
Yes.
All right, what did you do after you took these pictures?
At that point, I sat in the East Florida parking lot and sorted out the bus. It was there till approximately 11:52 a.m. At that point, I began following the bus and I contacted investigator Anthony Counts. I've been speaking to him on the phone while watching it. And he traveled to Blue Rock to assist me in trailing it. I actually lost it at one point and he was able to pick it up to follow it. Altogether, we were able to follow it to Hot Springs County. At that point, we discontinued following the bus and returned to Blue Rock.
And do you know what the relation is between burners and Cookies? What are those two things?
So Cookies is a marijuana company out of California. They are an international brand. They sell marijuana products throughout the world. Burners is a company here in Arkansas. Its permit number is 126, was licensed by us and was originally called Good Day Farm Blue Rock. Well, before it became Burners, and even before that, it was Harvest House of Cannabis. It's been connected to the Good Day Farm cultivation facility, and back when it was NSWE, it was connected to that one as well. Based off what I've been able to discover is Good Day Farm entered into some form of agreement to grow Cookies products here in Arkansas and sell said products to dispensaries. At that point, their dispensary became Burners by Good Day Farms as a way to advertise that same strain, or to that strain. If you look at the dispensary, you'll notice the coloration is similar, that it does have cookie emblems. If you go inside the dispensary, you can see that they have same coloration inside along with similar images. From my understanding is it's all in agreement with the cookie strain.
So the same brand logos, the same color scheme is on the dispensary that you saw in these pictures in the bus.
That is correct.
And in fact, the logo that's on the front of the bus is exactly the same as on the front of the dispensary.
That is correct.
I'll pass the witness.
If you'll allow it, before we get started, I just wanted to make a few comments about the exhibits that I've provided to you today.
Granted. Well, do we need to have you fix that before you talk about it, they need to be accepted as?
I guess at this point, given that Agent Hodges has testified to all the pictures, and I've gone through the procedure, I'll go ahead and make that motion to introduce the ABC packet, and I'll let Ms. G make the similar motion, I think, for hers as well.
Okay, your motion is granted.
Thank you. We've provided you with 3 documents here this morning, and before I get started, even with that, I should say, I'm Erica G. We're here representing Bernard by Good Day Farms today with my partner Steve Lancaster from the firm Rutland Z and Jennings. And we have provided some documents in addition to what Mr. Leibovich has provided today that I wanted to explain just briefly. The one with the pictures is pretty duplicative of what he provided to you, so we can just kind of set that one to the side. Okay. Then we also have a transcript, which is the hearing before the director that has already happened. We wanted to put that into the record so that we would have that available to us later, should we need to have it. And in addition to that, we've also provided you with a pre-hearing brief, which you have that documentation here. This pre-hearing brief is really focused on the constitutional issues presented by the advertising restrictions placed upon my client. And so, as I'm sure Mr. Leibovich will explain to you in just a moment, that this board is not given the authorization to make decisions on constitutional issues, but we do need to raise them in front of you. So we've put together this brief to do that in hopefully a pretty efficient way. So that you don't have to listen to all of the arguments here today. But we would like to mark those as exhibits 1, 2, and 3 by the respondent and offer those to you this morning.
Ms. G, one question I would have, the transcript itself, this would be a de novo hearing, of course, before this board. So, which is why we have also, Agent Hodges here to testify. There hasn't been any, I think, need for a transcript. His prior statements given under oath, that might be necessary if there comes a point where there was conflicting testimony. Otherwise, I don't think, just for the sake of having a clean record, the transcript serves a benefit to the board.
I'm not sure that it serves a benefit to the board, but we would like it to be in the record, so we've offered it for an exhibit here today.
Members of the board, Agent Hodges is here to testify. If his testimony veers from that at the director's hearing, I think there might be some relevance to a transcript. Otherwise, I don't think this transcript meets the threshold for a relevancy for the board.
Well, the rules of evidence do not apply. This is a proceeding before this agency in this matter. I think it's certainly quite relevant. And I would suggest to the board that there is no harm in allowing it to be in the record.
Ms. Lee, do you see the reason for this in the event that there was an appeal later on that you're just trying to have as much records in there that you're appealing it directly to the board decision?
Yes, sir.
That's what I'm trying to get to.
Yes, sir.
If that's the case, certainly Ms. G can proffer this as an exhibit. Again, if we reach the point where it's necessary to potentially show that there was conflicting statements at a director's hearing, I think it would be relevant. Otherwise, if the idea is to have this just for purposes of having an appeal, it may be proffered, and then simply wouldn't be reviewed by the board, but it would be proffered, and if the circuit court ultimately determines that it should have been considered because it was somehow relevant, if I'm wrong about its relevancy, then it's proffered and it's in the record. I should say it's lodged to the court, but it wouldn't be part of the record for the appeal. Wouldn't be a basis for this board's determination. I think that's the mechanism to have it follow up on appeal, would be to proffer it to the board. And then the board is free to not accept it at that point, but it still follows the appeal in the record on appeal if necessary.
In that case, fellow board members, I would lean to defer to our legal counsel on holding on accepting the transcript from the director's hearing, but move to grant the other 2 pieces submitted by the respondent unless you all have any feelings in the contrary. Okay, if that's the case, then just to make sure procedurally I'm saying this correctly, we had three documents presented to the board on behalf of the respondent, and we are looking to accept At this point, the licensee's pre-hearing brief document does not have an exhibit number on it, as well as the report for incident number 2022-04117 at this point in time on behalf of the respondent. Am I saying that correctly?
Sir.
Okay.
Mr. Chairman, if there is at some point contradictory testimony, they can't come back and share this correctly.
Absolutely. Would you like to continue?
Thank you. I don't think I have this on. Okay. Good morning. How are you?
Good, how about you, Mr.
I'm good, thank you. Could you tell us a little about your background and training?
Yeah, so I started my law enforcement career at the Conway Police Department, started in dispatch in 2013, and moved to patrol in 2015. Went to the Criminal Investigations Division of Conway PD in 2018, and then came to ABC in November of 2020.
And what are your responsibilities in your current role for ABC?
So my current role is actually an auditor position. I review mainly inventory stuff, including plant and non-plant inventory, check adjustment reports, do biannual inspections, things such as that. At the time of this investigation, I was in an investigator role, and I was investigating other violations regarding ABC rules.
Okay, can you tell me a little more about what you did as an investigator?
Sure. So we would review the security at the facilities. We would investigate any cases that were assigned to us, whether they were inventory related or if they were a complaint from someone else. We would do the biannual inspections and cover construction, day-to-day operations, security, various things such as that. Also still check the plants and everything like I do now. And we would handle things regarding advertising and stuff like that.
Well, what training did you receive in your position at ABC on how to determine whether there's been a violation of the rules?
Regarding training, we received the rules and we were to review them ourselves. And if we had questions, we would bring them up with our supervisors or our directors.
So what training were you given on how to interpret the rules and determine whether they would apply in any particular circumstance?
I wouldn't say we would receive any formal training. It's more so we would read the rules and then we would ask questions as they came up. Or if we came across a violation, we would once again bring that up to our directors and speak to them about it and provide them information.
Are you given, in that role, were you given any discretion on whether you included a particular item in an incident report or made it a warning?
Yes, we were.
And how did you make the decision on how to handle that?
Usually we would look at the totality of circumstances. Has any violation like this occurred before? What's the, how serious is the event that we're talking about? Is it something that should be easily recognized as a violation or not? Or is it, was it self-reported to us? Was it something that they tried to hide? Just a lot of different things. We look at the whole situation.
Okay, and do you have a manual in addition to the rules or other written materials that you use and are determining whether to issue a violation?
No, not anything that regards that.
Manuals on other topics?
We just got a new policy manual about a couple weeks ago.
What's included in that?
It's part of this general law enforcement policy, such as use of force, uniform appearance, stuff like that.
Gotcha. But not related to violation of these rules?
No, it's not.
Okay. So who makes the ultimate decision on whether to issue a violation?
I believe that would be Director Chandler.
ABC administration?
That's correct.
And when you have a question about the rules and regulations, you mentioned earlier that you're told to ask questions. If you have one, who do you ask your questions to?
So typically I first go to my supervisor, which is currently Glenn Percival, or I go to the CID supervisor, which is Christopher Craig. From there, we would go up to Director Potter and ask him. Occasionally, we would be directed just to speak directly to Attorney Chipley Fitch and go from there.
Okay. And do you know whether any of those people have a manual or other written materials in addition to the rules that they use to make a determination?
I do not know.
Is advertising defined in the rules?
I don't believe so.
And to make sure it's clear for the record, the rules I'm referring to are ABC's operational rules for medical marijuana.
That is correct.
And advertising is not defined as far as you know?
Not as far as I know.
Is it defined in statutes or elsewhere?
I'm not sure on statute, and I don't believe it's established in F98, but I might be wrong about that. I just don't know.
Okay, what about marketing? Is that defined?
I don't think that's defined in the rules, and I'm not sure on statute, and I don't believe it is in F98, but once again, I may be wrong about that one.
So when you were in your previous role, how did you determine whether anything was advertising or marketing?
So we would basically look at the situation. We had some discussions in-house about what could be advertising and marketing. For example, at one point we discussed that t-shirts could be seen as advertising and marketing. I don't believe there was ever any documents or anything produced from those. It was just kind of informal conversations.
Just t-shirts or other?
No, not just t-shirts. That was more so just an example, but, that they could be used as an example. Merchandise in general with the company's name on it or something like that would be seen as the kind of same way. Also, I know that the rules kind of address some things, regarding, or it could be no 98, but they address, like print media and stuff like that and how the audience is supposed to be selected.
Okay, but does that say what's advertising and marketing?
No, I do not believe it does.
So a t-shirt you've determined, or you collectively, enforcement has determined is advertising.
Yes,
Okay, what about a sign on the building? Is that advertising?
that is.
Does it matter in your view, the view of your agency, whether a sign or a t-shirt or some other material says anything about medical marijuana?
I don't really want to speak for the agency itself, but as regarding me, a lot of them say, typically they won't say medical marijuana, but a lot of places are titled, will have the name cannabis in their business, which would kind of insinuate that. That's how I think so.
What if, in your view, what if the particular item refers to a brand, but it does not refer to a product? And it does not include the word cannabis? Is that advertising?
It could be if it's still that business name.
How would we know?
How would we know if it's the business name?
How would we know? You said it could be. How would we know whether it would be advertising?
If it refers to the business name?
So your position is that if it includes a business name, then it's advertising?
Yes, that's right.
Okay, tell me a little bit about the disclosure statements. What needs a disclosure statement and what does not?
So according to the rules, the packaging of the product needs a disclosure statement, and any advertising needs to have those disclosure statements as well.
Okay, so any advertising also needs disclosure statement.
That is correct.
But again, there's no definition of advertising.
That is correct.
I'd like to talk a little more about cookies specifically. You explained that Cookies is an international brand based in California.
Yes,
Is it owned by Good Day Farms?
it is not.
Is it owned by Burners by Good Day Dispensary?
It is not.
Is it operating in multiple states?
Yes, I believe so.
And would you agree with me that the basis of its operation is to license its brand for use by other companies? Let me rephrase that. Does Cookies have a license in Arkansas?
They do not. Well, I would say Cookies does not. Burners by Good Day Farms does.
Does the company Cookies, does it have a license in Arkansas?
I do not believe so.
Do you think you would know if they did?
I would think so. I think all of our permits are licensed to individuals, but I might be wrong about that.
As far as you're aware, is Cookies a facility that is licensed to operate in Arkansas?
Cookies itself,
Cookies itself,
I would say no. I don't think we have a facility named Cookies.
okay, is, to your knowledge, are there cookies products being grown and sold by multiple facilities in Arkansas?
Define products, or let me ask, by products, do you mean the strain name or?
I mean, anything that is cookies branded. Let me ask it in a different way, that is simpler. Is there more than one cultivation facility growing cookies branded flowers?
So, there are other places growing the same strains, and I don't believe any others are using the same packaging and stuff like that. It's,
Okay. But there are other places growing cookies,
as far as the strains, correct?
and there are multiple dispensaries selling cookies branded products,
Correct.
not just Burners by Good Day Farms.
Correct.
Can you estimate how many dispensaries sell cookies products?
I'm not sure on the exact number, but I would think it's probably most of them, not a large majority.
So do you have any reason to believe that Good Day Farms owns cookies?
No.
Do you have any reason to believe that Good Day Farms determines actions taken by cookies?
No. Let me just ask one question. You mean the international brand cookies, correct?
I do.
Okay, yes, then, no, I do not think so.
Do you have any reason to believe that? Let me try that. I'm going a different direction. Let's talk about the bus. We looked at pictures of the bus, and you can see some portions of the bus pretty well in these pictures, others not as well. So it may be that you don't know the answer, but can you tell me whether the word cannabis or marijuana is anywhere on this bus?
Not what I can see, no.
As far as you're aware, it was not.
Correct.
How would the public know that cookies is related to medical marijuana?
I'd say it's a fairly popular brand within the cannabis industry. I don't know that every single person would recognize it as one, but I do think that at least a lot of people who are familiar with cannabis would.
Okay, but the general public would see a blue bus with the word cookies.
I would agree with that.
Did you know that Cookies also sells designer clothing?
Yes, I did.
How do you know that the bus was advertising medical marijuana and not designer
Well, the argument I'd make with that is that it was near the medical marijuana dispensary at the time.
Do you know that the dispensary sells Cookies brand designer clothing?
They do sell some.
Did you go into the bus?
No, I did not.
Did you approach the bus?
No, I did not.
Did you try to go inside the bus or approach the bus and you were prevented from doing so?
No, I did not.
How did you determine that there were no disclosures printed on the bus?
That was from what I could see of the bus. I did not see that on it.
What size are those disclosures required to be?
I believe it's 18-point font and 8-point font regarding packaging. I'm not sure that there is a requirement on the advertising.
So how do you know that they weren't on there in a size that was too small to see from 50 feet away?
Honestly, I don't know.
Did you talk to anyone at the dispensary about the bus?
No, I did not.
Did you talk to anyone in any other part of Burners by Good Day Farm or Good Day Farm about the bus?
No, I did not.
Okay, so when the bus left the spot, which was the parking lot next to the dispensary, if I understood you correctly,
That is correct.
you followed the bus.
Correct.
Why did you follow the bus?
Mainly to see where it was going from
Why would that be relevant to what you were doing, where it went from there?
there. Just concerns that it may go to other dispensaries.
And if it did go to another dispensary, what would be import of that?
It could still be seen, once again, as an advertising issue.
And in that case, who would be advertising?
Once again, I would like to say if and this kind of goes into one of the other cases involving the Cookies Corners. If the dispensary had that, it could be seen as that. It could also be seen as advertising for the cultivation facility since they create since they grow the Cookies Corners and packaging.
This seems to be a shifting definition of advertising and who's doing the advertising.
I'm not sure what the question is.
I think my question is, how is it that the licensees are supposed to know that this will be considered advertising by them at the bus parks and the parking lot behind the dispensary?
I think I'd have to look at the bus and look at their dispensary, considering it's the same images on both.
Do you have any proof that burners asked the bus to park behind their dispensary?
No, I do not.
What do you base your conclusion, on what do you base your conclusion that burners asked or caused the bus to be on a public road?
Once again, I did not say that they asked. I don't have any evidence that they did ask. Like I said, mainly we're discussing the buses regarding the emblems and the coloration and
Well, you know, one of the charges is that burners by Good Day Farms caused the bus to be on a public road.
for the bus to even get to the dispensary, it'd have to be on public road.
I would agree with that. But my question is, what is your proof that burners caused the bus to be on a public road?
And we don't have proof that burners caused the bus to be there other than just the images and the emblems.
Are there restrictions on liquor stores advertising that are similar to rules 19.1 and 19.2?
I can't answer that. I don't work the alcohol side on the medical marijuana side.
Okay, you have no familiarity with the alcohol side?
Not really.
Would you agree with me that there are restrictions generally on advertising by alcohol brands?
Once again, I'm not really familiar enough to answer that.
Okay. Have you ever seen an advertisement for alcohol?
I would say I did just this morning, actually.
Okay, so whatever the laws might be, it's not a complete ban.
Correct.
Do you know whether there are any advertising restrictions on controlled drugs?
Do you mean besides medical marijuana or,
I do, sorry, that you would buy at a pharmacy.
once again, I'm not familiar enough with those side of laws to say for sure if there is regulations or not.
Okay, can you describe the public interest that the advertising rules with regard to dispensaries are designed to protect?
Members of the board, we've had a lot of kind of hypothetical inquiries about what would or wouldn't be violations for others. And, you know, in terms of any questions about what is the policy behind a medical marijuana advertisement restriction or ban, this agent is not here to testify to that. He's here to testify to what he observed back on April 15th, 2022 in his capacity as an ABC enforcement agent. Certainly, Ms. G free to make the argument for public policy one way or the other by way of a closing argument or similar, but that's not the purpose of Agent Hodges being here today. He's here to testify, Agent Friday, just the facts, what he saw, what he observed, not public policy or differences of law, or opinions of law. That's not his role in this.
His role is to enforce the rules as he understands them and how he has been trained to enforce them, and that's what I'm trying to determine, what he has been trained to do, what he understands the rules to mean. Because he is an agent, or was an agent, on the front line enforcing the advertising and marketing rules.
Mr. G, he, as he stated, he's familiar with medical marijuana. I think you're welcome to we can all pick up what you're trying to put down on with the drugs and alcohol, but, you know, in respect of his time and everyone's time here, I would say let's defer to your closing statement to make those arguments.
Understood. Thanks. I do have a couple more questions about the bus. If we could follow that up. Did anything on the bus contain words that were deceptive, false, or misleading?
I would not say so.
Did it contain content that can be reasonably considered to target children?
I would say that to some extent you could say that the lemonade on the side or the name cookies could be seen as that.
Were there cartoon characters, toys, or images and items typically marketed to children?
No, not to there's cartoon character toys or things such as that.
Did it display consumption, encourage use as an intoxicant, or encourage excessive or rapid use or consumption of marijuana?
No, it did not.
And do you have a picture?
Not with me today, but I do have them in a separate report. I believe it was going to be the final inspection for that facility.
You testified about it, but I'm asking if there's a picture in the record.
Once again, not a part of this case, I don't believe so.
I have nothing further. Thank you.
Got a quick question. Stephen Hodges, when you were 10 years old, C2 buses, you gonna go to the bus with a big green broccoli on it, or one that says cookies and got a big cookie with a bite out of it on the side?
I'd be going with the cookies on the side.
Okay. You familiar with the big, soft, lovable blue Sesame Street character?
I am.
What was his name?
I believe it's Cookie Monster.
All right, have you ever seen him in adult films? Or just advertising for children on Sesame Street? Okay, have you ever seen him in something that, let's just say, is geared towards adults versus Sesame Street?
Not that I can speak to.
Okay, not to mean that you're adult film. Okay, sorry, just wanted to clear that up. That's what we rolled.
On that note, do you have a
If I may, just a couple of quick follow-ups to make this record clear, unless the board needs to interject. Agent Hodges, is there any other dispensary that you are aware of that has the Cookies logo as its signage on the dispensary?
Not on the outside of the dispensary, there is a cookie store out in the source in Rogers. I believe it's on the outside of the facility.
Okay, and I want to show you the packet that Berners has introduced. These do appear to be the pictures that you took of the bus. Is that accurate?
Yes, those two are good.
Do you see a disclaimer on any of those photos?
I did not.
Now, Berners, real quick, they were originally located on Rodney Perrin and they moved to Chenal. Did this April 15th, did that coincide with their grand opening or was that or after this?
So that's a little more complicated. So yes, they did move from Rodney Perrin. At the time they moved, they actually were under the name that they weren't living. When they transferred or moved from there to the other location, I believe they're still under that name. At that point, they did have the cookies and emblems and stuff like that inside the facility. From there, and I actually did the inspection on that facility at that time. From there, I believe that, I can't remember the exact date that they did move. It was a couple weeks before that. They had an opening where that facility went first open. And then they had this event, which I believe was the grand opening under their name change.
I think that's all I have.
Follow up. Another question. Ms. Gee, Why would you feel the need to put a disclaimer on the side of that bus? You said there was a disclaimer on the bus, correct?
No, they're actually, one of the charges is that there is not disclaimers on the bus.
Okay,
So I was asking how he knew there was not.
okay, so I listened to it.
Do we have anything further for Agent Hodges?
I have nothing further unless Mr. G has any more questions.
I don't.
Agent Hodges, you're dismissed for now. Thank you.
Mr. G, just for clarification, the exhibits that you have, do you want to mark the pictures as as burners 1, brief is 2, transcript is proffered 1?
That's fine.
With that, ABC has no further witnesses or evidence to present, so I'll defer to my Ms. G.
Please proceed.
We'd call Dorley Chandler.
Members of the board discussed this briefly with Ms. G in advance. Director Chandler is not a fact witness in this matter, and she reached the conclusion at the director's hearing that is a function of the director of ABC administration. She was not present during that day, didn't take these pictures. She's not a fact witness for this board. Making the director a witness in a case, first off, it doesn't pass the muster of relevancy. Second of all, if that's the case, that the director is going to be a witness in every case, then that would necessarily make her ineligible to make the rulings in the first place. She's got to make these decisions at the director level hearings, and if she's going to be a witness in every single case, she would have to be prohibited from making the rulings. This is very unusual, and given the fact that she's clearly not involved in any of the facts, we're just left with arguments of law, and that's something that Ms. G and myself can handle before this board readily. Director Chandler is not a fact witness for burners.
Your Honor, as I'll have it, the testimony from Agent Hodges is that the ultimate decision for whether to make these charges was made by the director. So I think that it's clearly relevant. Additionally, beyond the relevancy as a witness to whether the charges should have been made or what the proof was, there are questions regarding our constitutional arguments that the state has passed on the relevancy of the testimony of Agent Hodges. That can't be the case for the director. And for questions that we may have regarding the constitutionality or lack of constitutionality of these rules, the testimony of the director is directly relevant.
No, I'm not trying to make it easy on the first time we're sitting up here. I can tell you that in my time here, we've never seen the director brought forth in any hearing. Now, granted, we do not have as many medical marijuana hearings as we do alcohol, but on my first day here, we don't want to set the precedent to our.
Chairman, if I can respond very briefly, a couple of things. First off, this is a de novo hearing from Director Chandler's initial decision. And so whatever decision she made, and this is one thing that Agent Hodges testified to, and a bit of equivocation here, Director Chandler is not the ultimate decision maker here. Even the board is not the ultimate decision maker. Ultimately, if we go far enough down the line, it could be the Supreme Court of Arkansas, or the Supreme Court of the United States. And so whatever decision the director made, as you all know, is subject to your either approval or disapproval. And so, that's the reason why we have a de novo hearing. While she does make the ultimate decision at a director level hearing, when aggrieved by the director's decision, can appeal this up and have their full hearing before the board. And so it would be the board's, at this point, ultimate determination. And anyone aggrieved by the board can take this further. But I disagree with that assessment that Director Chandler or agency administration has the ultimate say. That would be with the board at this point.
If I might, I would posit that the state has the burden of proof in this matter. And if they are unwilling to provide any testimony or answer any questions, I think if we could have a stipulation that the state is not offering any proof on any of these matters regarding the constitutionality of these rules, then I think that we could pass that witness.
I don't think our board has the authority to decide whether a law is constitutional or not constitutional.
That is correct. This board does not have the authority to declare a statute to be unconstitutional. There is statutory basis for the advertising restriction. And I'd also just mention in passing that there is currently a pending case on the constitutionality of the advertising restrictions. That is currently before the circuit court here in Pulaski County. So the very issue that would be addressed by any constitutional law questions, that's already before a circuit court. And it's my understanding there hasn't been a ruling yet. I'd love to have a ruling, thumbs up or down, and just know which way we're going to go moving forward. But the issue's already before a circuit court. And so, having the director testify at this hearing, it'd be no different than Berners trying to call the board to testify at a circuit court hearing about whether or not it's constitutional or not. It's the same kind of issue. That party that has the burden of making that decision right here, that would be you, and it was the director at the director's level, and it'll be the circuit court at the circuit court level. That question of law will be determined by that fact finder. So there's not I don't see that there's a need, and as far as the constitutionality of this goes, I will tell you the state's position in the circuit court case has been, this is not constitutionally protected speech, because ultimately it does hinge on a federally illegal activity. So there is not any new information. We're not going to take a different position than has been taken in the circuit court already.
I believe it's an amazing proposition that this is not protected speech because it is potentially illegal under federal law when there is an Arkansas Constitution that provides protections for free speech. And the state is a partner in this enterprise in both regulating and accepting tax revenues from this industry. If the basis for saying that these rules are constitutional is because that the conduct is allegedly illegal under federal law, then I'll take that argument any day, and I can live with that. If that's the position that the state is wanting to take, then we can deal with that at the circuit court level. I will say that under the lawsuit that's pending in state court, there's currently competing motions for summary judgment. And for the lawyers in the room, that means that there is a contention that they're not questions of material fact. However, if that lawsuit currently does not deal with any facts relating to the constitutionality of these rules, what we're doing here today does, because the basis for those rules, what was done to create those rules and now enforce those rules, that is a matter for factual determination. And that's what we're trying to do here today. But again, if the state is willing to stipulate that they are not presenting any proof regarding the constitutionality of these rules, then we will not call this witness.
Mr. Chairman, the director's position is to take the agent's testimony, take the evidence that he brings forth, and then she goes by the medical marijuana rules, which we all have set in front of us now. I do not believe it's necessary to hear her testimony once again to determine why she made her decision. Just my opinion.
Anyone else?
I agree.
We've not done that in the past, and I don't believe this is the time and place to start.
I would tend to agree at this point as well. So procedurally, all of this is a first for I think everyone on the board, but certainly myself as well. How do we officially deny the request for?
I think that would be the first step, yes, sir.
Okay. As chairman today, we deny the respondent's request for Director Chandler to be a witness at this point in time.
Thank you.
But yeah,
And we'll.
but if you want to continue with your close, I think we're all know where we are going with it. But
Okay.
go ahead.
I will, and we'll let the record reflect that we attempted to call director and absolutely we're not allowed. Beyond that, with the proof that has been submitted today, I would ask that these violations be dismissed. There is a complete lack of proof that if it is advertising, was caused or at the direction or by Burners by Good Day Farm. First of all, there's no proof that this was advertising for medical marijuana. Nothing on the bus, again, indicated that this was an advertisement for medical marijuana. As someone who, prior to this case, I had no idea what cookies was, that it related to medical marijuana at all. And I think that that is true of the public in general. Again, nothing on that bus said medical marijuana. Nothing on that bus said Burners by Good Day Farm. Again, Cookies also sells designer clothing. Nothing to indicate that if there was any advertising at all, that it wasn't for designer clothing. Again, the state has the burden of proof on this. If it was advertising at all, again, it was for Cookies. It was not for Burners by Good Day Farm. There's no proof, and Agent Hodges agreed with this, no proof Burners caused the bus to be on a public road. That is the nature of the violation. There is no proof that the disclosures that the state contends are required to be on that bus. There is no proof that those disclosures weren't there. In fact, Agent Hodges testified that he didn't see any disclosures on there, but he doesn't know that they weren't. That is a failure of proof. The proof is that Burners by Good Day Farm is separate from Cookies. Burners by Good Day Farm is not controlled by Cookies, or vice versa. And there's no proof that any of this was done at the cause and direction of Burners by Good Day Farms. And finally, just for purposes of making my constitutional arguments, these are restrictions and unconstitutional restrictions on commercial speech. There's no proof that these rules directly advance the state's interest. Whatever that interest is, there's no proof of what that interest is. There's no proof that the rules are no more extensive than necessary to further the government's interest. And then there's no proof these rules treat dispensary licensees equally with those in similar industries, namely alcohol, tobacco, and pharmaceuticals. So for all of those reasons, we ask that these violations be dismissed.
Quick question. You say there's no control by Cookies. Do they sign a contract to raise and grow and produce their products?
There is a contract between Cookies and Burners, but there is no proof that there is any there's any direction relating to advertising.
Okay, so in your opinion, signing a contract has nothing to do with control. There's nothing in that contract saying they must do this, must do that.
That would depend on what the contract says.
Okay, so anything I've ever done where there's a contract involved is because of control. Contracts are for control. Nobody uses my product without a contract. That's so I can control them. So I think you stating that there's no control by Cookies to Bernard, that relationship, I don't agree with that if there is a contract.
Well, in my experience, contracts just simply set out the responsibilities and obligations between parties. That not
There's a lot of
necessarily,
fine print for control.
not necessarily, but I think more importantly, for purposes of where we are today, there's no proof that there's control by either one of the other. That's the point of the whole exercise today. The state has the burden of proof on these things. And there is a failure of proof to make
In
these.
that contract, there's nothing stating that burners cannot use Cookies logo, coloring, trademark, all that without Cookies consent.
If that contract was in
You're
front
a
of.
lawyer now, lawyers draw up these contracts.
Yes,
I-
but
I
but we don't
understand
have
what
the
I'm saying.
contract here to refer to.
Correct,
what
but I'm just going back to the
That's-
statement saying there was no control, there is no control by Cookies of burners. And I'm just stating the fact that I assure you there is.
Yeah,
I don't believe you can say that.
Well, maybe not.
Without that
Maybe
contract in
not.
front of you, there is no basis for saying that. And again, the state has the burden of proof on this. It would have been.
But without the contract in front of you, Ryan, you cannot say that they have no control.
It's not my burden to prove that it was or
Okay.
wasn't.
Okay.
It's the state's. And there is no proof on that point.
No proof in the room.
It's the only place that's the only place we are.
Right.
as director, am I allowed to ask questions?
Yes, sir.
Yes, okay. Freddie normally doesn't ask that many, so just make sure that it is not.
That'd be appropriate.
Okay, so one of your arguments is, it's a national brand, which I get that. I'm sure they have a great website, all those pieces, and that this bus, they sell, besides their licensing, their strains, they sell designer clothing of some sort. I've had the pleasure of seeing it, but that was part of y'all's case today. But there wasn't any evidence or photos provided of what is actually in that bus. So it is, at the end of the day, what these rules are built to do is protect the public, and in particular, those of children. And there's the potential saying that there could be clothes in there, but it is also just as likely that there's a bus that says Cookies that children could walk up to, and there could be cookies in there that have medical marijuana in them. There was no proof to show that it was actually closed or nothing else provided by either side. Would you say that's accurate?
I don't know what was in the bus. Right. Neither does the state. The state could have gone in and looked, and I don't think that there's any allegations or any violation regarding what was necessarily in the bus. The allegation is, and the violation is in the existence of the bus itself in Central Arkansas, is that that bus was a advertisement for Burners by Good Day Farm, an advertisement for medical marijuana without required disclosures, right? And that's all that the violation is for. And my point is that there are, and Agent Hodges agreed with this, there are other products that Cookies sells and that are also for sale in Burners by Good Day Farms that he acknowledged. that are designer clothing that is not medical marijuana. There, again, is zero proof in the record that this bus was in central Arkansas, one, at the direction or control of Burners by Good Day Farms, or that it was there to advertise for medical marijuana.
Right. But I don't think any of us would be here today for a case if the licensee or Cookies was able to provide a picture at the director's hearing showing a disclosure picture on the bus or a picture showing clothes inside the bus. Now, again, that's speculation. Again, we can't say that, but none of us would be here if that was provided, you know, as part of your hearings up to this point. It's a very good argument that yes, there is no, you know, we can't prove that there weren't disclosures on it, but if there were disclosures on here, we wouldn't be here right now anyways, because we would have, you know, been proven and we all would be moving on with our day. But your point is valid of what you're saying as well. And, you know, at the end of the day, the burden of proof is on the state. That's my only comment on all this. Do you have any rebuttal at this point?
Very briefly, a couple of things. First, to the issue of control and whether or not this was advertising on behalf of the dispensary. You know, we see that the logo for this bus is identical to the logo that is on the dispensary itself. Second of all, I mean, the coloration scheme, and they candidly agree that there is a contractual relationship between Burners and Cookies. That contractual relationship has nothing to do with selling designer clothes because Burners by Good Day Farm isn't in the business of selling designer clothes. They're in the business of selling medical marijuana. The other thing, talking about the element of control, as you heard Agent testify, the bus was moved upon ABC's request. So if Burners was able to get this bus moved upon ABC's request, then there is clearly some modicum of control between Burners and Cookies. What they have essentially done is advertising with an extra step. If this is permissible, then what every dispensary and cultivator is going to do is they're going to form a separate company that holds the brand rights, that will advertise the brand. And then the cultivators or dispensaries will say, oh, this wasn't us. This was, you know, we may use their brand, we may use their trademark, but we didn't do the advertising. We don't control what the brand does. And that just doesn't pass the smell test. Clearly, there is this relationship. It is intended to bolster the brand both of Cookies and of Burners by Good Day Farm as well. So there's clearly this similar relationship. As to the issue of proof, like for the disclaimer statements, you know, the agent testified, he saw no disclaimer statements. We produced photographs of the bus. If Burners has any evidence that those disclaimers were on the bus, they can produce some. But we've met that burden of at least showing, hey, the agent saw no disclaimer statements, took plenty of pictures of this bus. There's no disclaimer statements on that bus. We don't have to prove definitively beyond a reasonable doubt that this isn't a criminal trial. This is an administrative hearing. And I would submit that Burners has not presented any counter evidence to suggest that those disclaimer statements were on the bus. It's very hard to prove a negative. Really, if we look at this and we see there's no disclaimers anywhere in these pictures, they have some obligation to come forward and say, oh, it was here, you just missed it. Finally, to the question of burden of proof on the constitutional question, that's a shifting burden. That is on the burden of the party saying that the law is unconstitutional to make that showing. So for ABC's purposes today, again, I'll just say that's not for the ABC board. We have no authority to declare a statute unconstitutional, and that would be on the Burners to show.
So with that, what's the board's pleasure? Or do you have any further comment on your side before we?
I think the only thing that I would add, and this is undisputed, the testimony is there is no proof that Burners caused that bus to be on the public road. And there is, the proof was that Agent Hodges did not inspect the bus to look and determine whether there were not disclosures. And all of those things were available to Agent Hodges to determine. He did not.
The only comment I would say before we kind of deliberate on it, I think it's a challenging piece right here, and I don't think this will be the last time this comes in front of the board with how the rules are written at this point right now. I think it gets to be especially difficult when you see a outside state brand that is selling has licensed products to various license holders. If we had a situation where we saw the Cookies logo on the outside of multiple dispensaries, and this truck was going to multiple different dispensaries and license holders, that becomes a much bigger challenge of how to determine that, because at that point it is an out-of-state group that is licensing products to these permit holders, and I see that in a lot of ways like a out-of-state liquor business. It's at various liquor stores. It's hard to determine what's being promoted by the liquor store and what's by out-of-state brands. But I think that really comes down, it really falls down on the Medical Marijuana Commission needs to look at revising some rules that stipulates more of what this is going on here, because this isn't going to be the last time we see this, with medical marijuana becoming more nationalized. That's just my 2 cents on that. Is there a motion?
I'll make a motion. Regarding Alex Gray, Burner by Good Day Farm, National Parkway, Little Rock. The appeal violation order, they were fined $1,250. On the counts that they were in violation of Rule 19.1 and 19.2, I believe there's sufficient evidence to show that they were in violation of that by the agent, so I would suggest that we uphold the director's decision.
Okay, do we have a second?
I'll second it.
All in favor?
Aye.
Motion carries. Director's decision is upheld at this point in time. Thank you for your time today.
Thank you.
We have a pleasure with you all for the next one.
Would you like to take a short?
Yeah, you all like to take a recess for a moment, maybe 10 minutes. Reconvene. Thank you. Commissioner Blue on this constitutional determination coming up.
No comment.
You did very well.
I agree with that assessment. It's
Are we gonna have the same witnesses for both? Do they need to be re-sworn in?
There is one additional witness that ABC would have, but Agent Hodges would be here again.
Does Agent Hodges need to be re-sworn in?
He's already been sworn in, unless,
I didn't know whether they.
unless there's a desire to have him sworn again for another matter.
Okay,
Oh, I'm sorry.
Oh, I did that. That's all fine.
thank you. We won't be referencing any of the other exhibit packets from Good Day Farm.
Yeah. They look similar. I'm just gonna give this to you.
You've already got,
We'll handle it in the same way.
okay. Do you have a preference on your exhibit numbers?
I don't. Whatever you like. You got a lot of pictures.
I like-
that are
I like them.
Pretty much the same. That's okay.
Please, board, I'll commence, again, with the sort of procedural aspects of this case, how we got before the board. There was a notice of hearing directed to Good Day Farm, Arkansas, permit holder Regina Thurman, that on or about April 11, 2022, facility advertised or marketed its products to the public, violation of ABC medical marijuana oversight rule of 19(1)(a)(1) and Arkansas Code 2056-305, 2 counts. There was a separate charge related to failure to properly label medical cannabis to patients for individual sales. A director's hearing was held on or about September 2nd, 2022. And at that time, a couple of things, the permit holder did not contest the second charge on the labeling, but the director did uphold the violation for the 2 counts of advertising. That was duly appealed to this board by a permit holder, and a notice of hearing was sent to them, notifying of the hearing to date. That is the procedural aspect of it. I would note, Ms. G has indicated that permittee does not wish to contest that, once again, does not wish to contest the labeling violation. Is that accurate?
Exactly.
So we are left, again, with simply the advertising violation before the board.
Okay.
With that, I will call Agent Hodges.
Sorry, yeah, could just a second. I think Mr. Lubavitch and I have discussed a possible stipulation. Some of the testimony that we heard in the previous case, the burners by Good Day Farm, some of the questions of Agent Hodges' background, definitions, training, things like that, would be duplicative of what we would do in this hearing. Also, our request to call Ms. Chandler as a witness, we would renew that for this hearing. One of the things that we discussed as a stipulation, if the board would agree, is that the record that was created in the Burners by Good Day Farm be made a part of and incorporated into the record for this hearing as well. It would be things that we would ask, both of us would ask the board to consider, but also for purposes of an appeal, possible appeal of this matter, that would also, the testimony and the arguments made in the previous matter would also be considered and made a part of the record in this matter, if I stated that correctly.
Yeah, and I see no reason for us to sort of plow the same ground that we literally just did 5 minutes ago. And that, there are a couple of facts that are going to be a little bit different that we'll need the agents to testify to. But we'll stipulate that the arguments as to training and spotting advertising and the on the record, that those would all be the same arguments, the same ruling before the same board that just heard the same type of case.
So is that a motion you want to, or how do you want me to officially, do you want me to just accept that, or how do I need to procedurally?
I think that would be a joint motion, joint stipulation, if the board is willing to accept it.
I believe the board would be willing to accept it. I don't need to.
So sorry. So the record from previous would be part of the record for this as well.
Yes.
Since we all just did this and all just had the same.
Okay, granted.
One other housekeeping item, if I could. We also provided the transcript from the director's hearing for this case below. And again, like in the last case, I will, I think it's fair to assume that you would agree to accept that as a proffer, but not as exhibits.
Yes. And then as far as your exhibit packets, if you want to go ahead and present those,
Yes.
maybe this nice colorful one with the incident number 2022-04-458 is exhibit 1
Yes, sir.
for the respondent. And then exhibit 2 being the
Pre-hearing.
pre-hearing brief.
Yes, sir.
And then does the medical marijuana sign have a packet they'd like to invent at this time?
Yes, the packet that was distributed to you, the singular one.
Exhibit 1.
Exhibit 1.
Okay, granted.
Thank you.
All right.
I think that clears up all the housekeeping. So with that, we call Agent Hodges back.
All right. Welcome back, Mr. Hodges.
Thank you.
Agent Hodges, you were previously sworn in. That's right. We previously discussed your experience in training, so without further ado, this matter was sent to us regarding a report on April 11th regarding advertising by Good Day Farm Cultivation. Can you tell the board what led you to commence this investigation and what you discovered?
Yes, so this investigation goes back to what originally started as a courtesy visit at the new Good Day Farm Little Rock Cookies, or currently known as Burners location out in West Little Rock. I went by there to do a probation check after buying inspection and to also just check up on the recent move. And while I was there, I was able to view new packaging that the store was selling. This packaging has several photos that are in the packet that was given to you, which shows various strains or products or various products and one of the strains from the medical marijuana facility. As you look at them, you'll see images such as a strain called Pink Rose, the soap, apples and bananas, Collins Avenue. And you can also see that on the images of the back of these packages, you can see the Good Day Farm Cultivation, which shows the business name Good Day Farm, and it shows the UIN number that begins with M00123C, which 00123 is the permit number for Good Day Farm Season Cultivation Facility. Basically would be unique to that facility or products from that facility. Altogether, I was able to photograph, Pink Rose, the Soap, Apple Bananas, College Avenue, Blue La, Red Velvet, Medellin, Jealousy, and Jealousy, while at that facility. All the product inside them, that's actually, or what's believed to be marijuana product inside them.
Marijuana flower?
Yes, that's correct. And as you can look at the packaging, you can see that it'll say net weight down on the, lower, left side of the packaging. It'll say net weight, and that's, in, for example, Pink Rose, it says 3.5 grams, which would be an eighth of medical marijuana flower. You can also look at the UIN, so it'll give you net weight, THC percentages, all that information on there. I took photographs of these items, partly for informational purposes, for us looking at that way we know what packaging, what product is out on the market, and to document what the packages look like. Altogether, we saw that it had various, or what I believe to be different brand names at the time, include cookies, mints, lemonade, which is later determined to be a line of cookies, and Grand Flora Genetics. From there, I was able to, or from there, we were doing a biannual inspection at National Dispensary on April 11th. It was myself, Senior Auditor Allen, Audit Manager Percival, and CID Supervisor Kirby. While we were there, we noticed that there was a large display for cookies. And if you once again get referred back to the packets.
Agent Hodges, is this the display that you saw at Natural Relief Dispensary?
It is.
Or page 11?
Yes, sir, page 11 of the exhibit package, for reference.
There was that photo along with the next photo too was kind of like a display for the flower itself. The Burns Rugged Farms also had a similar display, and basically they put them inside these kind of these caps that are clear that you can look and see the flower. They're connected by wire to that display. In this photo, you can see the same thing with the packaging. You see products that are trade names such as Red Velvet, the Soap again, Pink Fronts, Collins Avenue, Cereal Mill, Gary Payton, Lemonade, and Medellin. Once again, multiple different strain names with different images. Looking at this, you can see that some of them, such as the Collins Avenue packaging in this display, has a flamingo on it. The images, and I can't quite read what that one is for strain name, but it has what appears to be a form of a person on it. A lot of these have pictures of food or reference common foods. And from there, we spoke to Ryan Ring, who is the manager of Natural Relief Dispensary, and to discuss the situation with him. We noticed that there was also packaging with a fly on it. That said fly. We made contact with Brian Rink and David Bird about the display, and they mentioned that they had another example of the packaging that actually was on the display because they felt like it violated the rules. This image is also provided in that package. As you can see, it is a strain name called Fish Scale.
What page is that on?
This one is actually in the Good Day Farm packet, and notes 30 and 31 at the bottom right hand corner.
Okay, thank you.
So on this packaging for Fish Scale, once again, we can see cannabis flower net weight 3.5 grams. We can see the Arkansas Medical Marijuana logo on it as well. And we see what appears to be the image of a fish in some type of white powder. On the back of it, there is no markings, no UIN label or anything that's on it, but it does show the cookies company name on top of it. It also has the medical marijuana warnings that are the Arkansas Medical Marijuana rules on it. So I would like to provide a sample of this packaging from our review as well, which Brian Rink and Dave Byrne allowed me to keep. So on April 19th of 2022, myself, Investigator Clark, Senior Auditor Allen, and CID Supervisor Clary were conducting another biannual inspection at Delta cannabis dispensary in West Memphis. During the inspection, we located a bunch of boxes in the delivery area of the facility. Now, this is in the back of the facility. It's not where patients can see it. It's not where the public can see it. It's in a secured area, in a restricted access area of the facility. While we're there, we noticed that it had signs. Once again, there are photos of this as well in the package that showed that it was from Cookies. There was shipping pack lists that showed where it came from. Address.
Let me just, well, is this what you're referring to?
Yes, it is.
Okay, on page 19 of 31 again. Good Day Farm.
And just for a point of clarification, make sure everyone on the board understands, it took me a second to catch up. On our previous hearing, it was about a specific dispensary. This is Good Day Farms, the cultivator, and you're referencing seeing these products at multiple different dispensaries as part of it, your inspections.
That is correct.
Okay. Continue, sorry.
So I noticed various addresses, a lot of them from out of state. One address came back to 300 Frank H. McGraw Plaza Suite, 111 in Oakland, California. Another one was a Cookies Corner at 1551 Academy Street, Ferndale, Michigan. We spoke to Brian Falls about these boxes that are in the back of his dispensary, and he explained that he did not have much knowledge of the displays because they actually came, or they were from the other dispensary owner. He's the one who got it. I asked Brian Falls if they were planning on displaying out-of-state products, knowing that Cookies was a international brand and had products out of state. And he said they did not, and that Cookies was being grown by Good Day Farm, Arkansas. He said that the brand Cookies will opens up Cookies corners inside of dispensaries so they can promote their products. While we're there, he did not have it displayed, and we discussed that. After that, Investigator Clark mentioned to me that he remembered seeing something similar in Crop. Crop and Delta, from my understanding, are somehow connected to one another. He advised that he would stop by there and follow up on that. I later received a call that Crop also had similar displays at their facility, but I'll allow him to testify to that.
Agent Hodges, so the only up-it display, the only one that you saw with this Cookies, this was at Natural Relief Dispensary.
Correct. That's the only one that I saw. The one that Investigator Clark saw was up as well, and we have seen these up at other locations since then.
Okay.
Including Delta. I actually was present at their meeting just yesterday, and they currently have a Cookies corner up at their facility now.
All right, thank you, Agent Hodges. I'll pass it back.
Thank you. So Agent Hodges went to Berners on April 4th to conduct a probation check. But the violations that you had issued had nothing to do with the packaging you observed at Berners, correct?
You mean regarding why we were there to check the probation check?
You didn't issue any violations at Berners relating to why we're here right now, right?
Correct.
So then you went to Natural Relief Dispensary a week later. Now the relationship between Natural Relief Dispensary and Good Day Farm is purely customer and producer, right?
From my understanding, yes.
And there's nothing in itself wrong with having a display that shows what products are available for purchase in the dispensary.
Correct.
And this display was for Cookies, right?
Yes, it was.
And Cookies is an international marijuana brand, right?
Yes, it is.
And I believe you said that the display in Natural Relief Dispensary showed packaging, but there was no product inside that packaging.
Correct.
Okay. Now, that packaging did not have a UIN from Good Day Farm.
Not that I saw, I don't believe we took them off and looked at the back of them, which, as you can see in the photos from, Good Day Farm, Little Rock, that was where the, label would be, but I don't believe we took them off check, so as far as my knowledge, no, they did not.
You don't believe they did?
Correct.
And packaging didn't have the name Good Day Farm anywhere on it either, right?
Not that I saw.
You noted that one of the packages had a flamingo on it. But you have no proof that cannabis is being sold by Good Day Farm containing a flamingo on their packaging, right?
That is correct, and actually, if you look back at the photos that were taken at Good Day Farm, Little Rock, you can see that same strain, the Collins Avenue strain. And you can see, and I don't have the page numbers on mine, so I'll pull it up.
And Agent Hutchins, I'm asking you about.
Correct, I'm once again discussing the same thing, so that is Collins Avenue as the strain. And if you look at the image, it's on page 22, you can see that same strain, the Collins Avenue strain, and it does not actually have the flamingo on it, on that one.
Okay. So that, but as far as a packaging that you saw in Natural Relief Dispensary with a flamingo, that packaging with a flamingo is not being sold by Good Day Farm.
Not as far as I know.
And same is true with the packaging you saw with a fly. And you have no proof that Good Day Farm is selling that product with a fly on it, correct?
I don't believe I've seen the packaging what it looks like at a dispensary. Not that I can recall at least.
And the package with a fish, in the words fish scale, you don't have any proof that cannabis is being sold by Good Day Farm containing that packaging, right?
Correct, once again, I don't recall ever seeing it at a dispensary or for selling.
So these packaging that were on the display at Natural Relief Dispensary with a flamingo and a fly and this fish scale, those are not packaging that is sold by Good Day Farm, correct?
Once again, to my knowledge, no, it could be, but I don't recall ever seeing it at the dispensary in those. And that's kind of shown with the Collins Avenue that it would appear that they may be using other packaging.
But would that tell you that the packaging that you're referencing with the fly and the flamingo and the fish scale, that would have come from somewhere other than Good Day Farm?
I wouldn't necessarily say that it proves that it came from somewhere else. I would say it's possible.
Would it be more likely that it didn't if Good Day Farm is not selling that product with that packaging? Would it be more likely that it came from somewhere other than Good Day Farm?
I don't necessarily want to say that it would be more likely. I don't necessarily agree with that. I'd say that it's possible that it came from somewhere else.
Quick question on all that, just to clarify what you're saying. At this dispensary where the fish scale, for example, or the Collins Avenue with the flamingo was seen, was that the same one where you saw boxes that had products shipped, it seems like directly from an out-of-state cookies business?
I know it was not. That was at a different dispensary.
Okay. Sorry. Continue.
Okay. But we know that, or at least you believe that the packaging that had flamingo, fly, and the fish scale were not being sold in that packaging by Good Day Farm. but those packages were on the display at Natural Relief Dispensary.
I would agree that they're on display at, Natural Dispensary. You mean with product, they weren't being sold with product inside of it, to my knowledge, right?
I believe he testified that there was no product in the packaging that was out on those displays.
Right, I'm just trying to clarify the question, but I'm sorry. As far as the first part of that question, you mean that I do not know that Good Day Farm was using those packaging for actual products, correct?
Now, you were, when you were at Natural Relief, they told you the reason for the packaging being there was to display cookies products, right?
Correct.
But you have no proof the display or the packaging came from Good Day Farm, right?
I agree that there's no proof. I didn't have a shipping label or anything like that or an invoice that showed that packaging. Correct.
And there was no UIN or the name Good Day Farm on that packaging, right?
Correct.
You didn't ask anyone at the dispensary how it acquired the display, did you?
I do not believe we did. I know we discussed it with them. I can't recall what exactly they said about it other than that, I think it's that other thing.
Again, you didn't ask anyone how it acquired the display.
Once again, we may have, I don't recall if we did or didn't.
So in your testimony before the director's hearing, I asked if you want to look at that transcript, a copy of that. I've got an extra if you need. Page 19. Line 9. I asked you, did you ask anyone at the dispensary how it acquired the display? What was your answer?
And it says, I do not believe we did.
And you didn't ask anyone at the dispensary if they considered this to be an advertisement for Good Day Farm, either, did you?
Once again, my answer to that was, I do not believe we did.
You think that's inaccurate?
The transcript, no, I do not think the transcript is accurate.
And you didn't give the dispensary, this dispensary a violation for having this packaging on display, right?
I believe we actually did. I don't have a copy of their final inspection report in front of me, but I think they did. I know we discussed it with them, and maybe it was the verbal one instead, but I can't recall.
What was the nature of the violation?
I believe it would be under the advertisement rules as well.
How did this violate the rules?
That goes back to the images on the packaging.
And what was it about the images on the packaging that you considered to be a violation?
We got pictures of animals on there. We've got an image that appears to resemble a human, various other things as well.
And what makes that a violation?
Way the rule is written.
I'm sorry, but just what rule exactly are you referring to that's a violation? Can we reference like the rules where it references advertising just so we can follow along? You know that?
It would be section 19.1.
Okay, I'll come to the video.
Yes.
Okay.
Just for the board's consideration, and I don't have that violation of what
Natural Leaf may or may not have gotten this violation. It's been some time ago, and I see a lot of these violations. But it is conceivably possible that there was actually 15 one, which talks about the packaging for medical cannabis, which cannot be allowed to have pictures of an animal, vehicle, person, or character. That's kind of down on the bottom of that second page on the packet. Now, and just to be clear, that violation was not given to Good Day Farm in this. So discussion about their packaging. I don't know that we need to, I don't know how much you guys want to drill down on that. Not trying to play out the ball with the board, but that's not the gist of their violation. Their violation is that as a cultivator, they're making these strains, they're putting their displays, and that's the advertising. So the packaging, and honestly, I don't know that Natural Leaf got a violation for this. They may have, it's just been some time. And that's the only reason why I think there's any discussion or any relevancy to the packaging. Clearly, it's been changed, and so Good Day Farm does not have a violation for violating the packaging rules as it relates to having an animal or a character, not today, not before this board. And so it's, I hate to say we're kind of veering off a bit, but I kind of feel like we are. The package itself is not a violation, the fact that it's packaged in a certain way. The display is the advertisement for the cultivator.
So it's the display that caused the violation that we're here for today, not the packaging on the display.
It's not the packaging, and as I just noted, the ones that were problematic have been addressed in prior violation hearings and discussions. You know, Collins Avenue does not feature flamingo on any of the packages that I've seen. I don't know if that strain is still in circulation or not. There was a couple of others that had person's picture on it. Those have all been resolved to ABC's satisfaction. So the only question, to my mind, to my thinking before the board is, do these displays constitute advertising? And would Good Day Farm violated the advertising rules by burners, or excuse me, by cookies, providing these displays to the dispensaries?
And it would be the ABC's position that it would be, to drill it down specifically, section 19.1 B I 2C would be the specific one. Similar images or items typically marketed towards children's.
No, sir. It would be our position that A1, excuse me, at the statute. I think it's the same. 19.1 A1, okay, it's the same rule, and then the statute, 2056-305 A1. Cultivation facility may not advertise through any public means or means to market its products to the public. So the cultivators there's a blanket prohibition on any advertising with them whatsoever. And it's our contention that these displays are marketing or advertising for the cultivator.
Even though they're inside the dispensary.
No, they're inside the dispensary. It's not viewable to the public. We all know that. We all agree to that. That's part of the rules for our dispensaries, that you can't see what's going on inside the dispensary from the outside. But displays are a form of advertising, albeit to the patients who are in the store, to the caregivers who are in the store, to minors that might be accompanying a parent into a dispensary, because that's part of our rules that we allow that as well. We have a similar, and I'm getting off into argument now, and I hate to do that too much, but we have advertising restrictions, for example, on the alcohol side for our wholesalers, and the sort of displays that wholesalers can put in stores. So that's the gist of it, and I don't know if that saves us any time or drags it out further, but hopefully so we're all clear. It's not the package that ABC takes issue with. That's been resolved previously. So the question is these displays themselves.
Okay. That just speeds it up a little bit for all that stuff.
Yeah, no, that's very helpful.
Yeah.
Thank you. So we're focusing on the displays. And to follow up a little bit, what was just mentioned. So these displays were inside the dispensary, correct?
Correct.
And it was not visible to the public from outside the dispensary.
No, it's not.
So unless you have a card, you're not going to be able to see that display.
That would be incorrect.
Okay, tell me how that's incorrect.
Well, as stated before, if a child accompanies their patient parent into the dispensary, or it could be a situation such as a contractor going in there, there are reasons to enter a dispensary without having a medical marijuana card. If they need repairs done, if they're having an electrical issue, they need an electrician to come in, or once again, a minor child whose parent couldn't find someone to watch them while they went to the store, they can accompany them into the store as well.
Okay, so let's go back to your transcript, page 20. I asked you, line 6, so unless you have the right to be in there, if you have a card, you're not going to see that display, right? You answered what?
I said that is correct.
So, and Mr. Leibovich just read to the board what the rule is. And what is your understanding of what the rule prohibits?
Regarding advertising by cultivators,
Yes, sir.
that they're not allowed to advertise. They're only allowed to advertise to dispensaries and processors, which is established.
Now, that's not completely correct, though, is it? What does the rule say?
So 19.A says cultivator advertising, marketing, medical marijuana. Cultivation facility and processor advertising and marketing. Cultivation facilities and processors shall not advertise through any public medium or means designed to market its products to the public.
Okay.
Cultivation facilities may market their products directly to dispensaries by any means directed solely to the dispensaries and not available to the public. Processors may market their services directly to licensed cultivation facilities and dispensaries by any means directed solely to cultivation facilities and dispensaries and not available to the public. A cultivation or dispensary facility shall not use any of the following images within an advertisement, including without limitation, across excuses or any other symbol that is commonly associated with the practice of medicine or text marks.
So it has to be advertising designed to market its products to the public, right? To the public.
We can take judicial notice. The rule says what it says.
Okay.
The board has it.
Yeah. So this display is inside the dispensary where it can't be seen from outside, correct?
Correct.
Do the rules define public?
I do not believe so.
Do you know what the dictionary definition of public is?
Don't say I couldn't quote it.
So I'll tell you that it's all people. So it's not people who are inside the dispensary. It's everyone. And this display is not directed to all people. It is only people within that dispensary who have a right to be there. But that is not the public. Would you agree with me on that?
Once again, I think patients could be considered public as well.
But it's not all of them. They could be a piece of the public, but they are not, patients are not the public. The public is everyone.
I think this line of inquiry calls for a legal conclusion.
We get the idea of what's being argued.
I mean,
Okay.
yeah, point's well taken, but I don't think this witness is available to get a legal conclusion.
Well, he made the determination that this was advertising to the public by issuing this violation. And so my question is this truly directed to the public? Because it's only viewable by people inside the dispensary who have a right to be.
Agent Hodges writes the report, sends it to the administration, administration makes a determination, send a violation or not, director makes a determination, whether it is a violation or not. So the legal conclusion here now rests before the board, whether or not patients within a facility, within a dispensary constitute public under the rules or not. And so it's never truly been Agent Hodges' determination. He reports the facts of what he saw. We made a determination, Director Chandler made a determination. Now that decision rests with you. We can dispute that point and make our close, but I think that's for the attorneys to do, not for witnesses.
I agree.
Okay, and there's, we understand that there's not a public, not a defined term in the rules. Has there been any kind of training or any other type of manual or anything that describes or gives you any guidance on what is the public?
I just informal discussions like we discussed earlier.
So you've had informal discussions with the administration on what the public means?
The administration, others within enforcement. I don't know that specifically what public means, but more so how that was read.
So is there, in any of your discussions that you've had, has the question of what constitutes the public been raised?
I don't believe so. I ain't gonna say no on that.
Let's move on to Delta cannabis. And there's no violation relating to Delta cannabis, but I do think that the facts are important. So you and others from ABC did an inspection at Delta in West Memphis on April 19th. And I believe your testimony is you saw several boxes wrapped in plastic and had pieces of paper with the words cookies on it.
Correct.
You didn't inspect the contents, but you were told they contained shelving for a cookies display.
That's correct.
And then the packing labels that you described and shown the board indicate that the shelving came from California and Michigan before being delivered to Memphis, right?
Yeah, that's correct.
Okay. The name Good Day Farm is not anywhere on any of those boxes, packing lists, or paperwork, right?
Not that I recall seeing.
So there's no proof that the display came from Good Day Farm, correct?
I would agree with that. That I didn't have an invoice or anything that it came from.
And you were told by Brian Falls that the boxes contained a display for cookies products.
It contains display to show these products, yes.
And he also, Brian Falls also told you that Brain Cookies opens cookies corners inside dispensaries to promote their product, right?
Correct.
Again, Cookies opens Cookies Corner inside dispensaries to promote their product, cookies products, right?
Correct.
And you had no proof of an agreement between Delta and Good Day Farm regarding marketing cookies products.
Correct.
And you didn't ask Brian Falls if he considered this to be advertising for Good Day
I do not believe so.
Farm. The displays did not come from Good Day Farm, right?
As far as I can tell with the packaging and everything, I don't think so.
The Cookies opens Cookies Corner displays inside dispensaries to promote their products. It was your belief at the time that Cookies was aware that there were other cultivators, not just Good Day Farm, who would be growing cookie strains to sell in Arkansas.
Correct.
And Cookies had an incentive regardless of who is growing the product, to have a display in those dispensaries.
You mean Cookies the company had incentive or?
Yes.
Okay, yes, I would agree with that.
Let's move on to Crop Dispensary in Jonesboro. You didn't go to that one, right?
Correct.
Investigator Clark went there. I don't believe he created a report.
I don't have a copy of his supplement if he did one or his report.
It's not in the documentation provided in the demolition.
Correct.
And so, Investigator Clark sent you a text, showed images of the cookies display, and then he sent you a picture of the empty shelves with the cookies over one and a C over the other. Is that right?
Correct. Yes, that would be.
Okay. And from looking at that picture, they don't show Good Day Farm anywhere on display, correct?
They do not.
And so you have no proof that the display came from Good Day Farm.
Correct.
And there's no proof there's an agreement between Crop Dispensary and Good Day Farm regarding marketing cookies products.
Once again, all I've got is the images, probably better for Investigator Clark to testify to that since he is present today.
And no proof that Crop Dispensary considered this to be advertising for Good Day Farm.
Once again, all I've got is the images and what Investigator Clark told me. Probably best for him to testify to that since he is here today.
Okay. So there's no proof that Good Day Farm was marketing cookies products to the public. Would you agree with that?
You can answer the question, but I'm going to say the same thing. I think this comes down to a legal conclusion that ultimately is what the board's deciding. Go ahead. What's good to, I'm sorry, would you restate the question again?
Yep. There's no proof that Good Day Farm was marketing cookies products to the public. Correct?
Would disagree based off the displays and the packaging that we found at other locations. If you mean that they were not the ones that set up the displays, I'd say there's no proof of that.
Okay. So beyond these displays, just the existence of the displays themselves, there's no proof that Good Day Farm was marketing cookies products to the public. Do you agree with that?
This, another legal conclusion. Members of the board, that, was there other proof that Good Day Farm marketed? That's for you to decide ultimately. I would argue that there is further evidence that this is Good Day Farm. As I argued in the last matter, this is advertising with an extra step. It's not Good Day Farm who is directly performing this advertising. There's no evidence, and that is true. There's no evidence that Good Day Farm built these displays, shipped these displays to the dispensaries. But Good Day Farm clearly has a relationship with cookies. And that's, very clear from the images of that you have before you. They are growing strains under the cookies brand. And so, yes, there's absolutely evidence that it's promoting Good Day Farm. But the question of, does it, Good Day Farm was personally involved, or that the company itself was involved with placing these displays? Well, no, but again, it's advertising just with an extra step, third company that it is tied to Good Day Farm. So, I understand the point. I think we've about gone as far as we can with Agent Hodges on opinion on that.
I would tend to agree. And if I might, I'm going to follow up a little bit with
Mr. Hodges' previous testimony. So, Mr. Hodges, if you look at page 32 of the transcript on line 17, and I asked, and beyond these cookie corner displays, do you have any indication or proof that Good Day Farm was marketing cookies products to the public? You responded, are we discussing the cultivator or the company at this moment? I said, well, who was the violation addressed to? You responded, it would be addressed to the cultivator on this one. And I responded, yeah, that is what I'm talking about. And what was your answer on line 2 of page 33?
I would say, or I said the cultivator specifically, I would say no. As for the company, once again, we had, it says an audible, from various other groups that were associated with other permits.
But the violation is against the cultivator. It's not against anyone else, right?
Correct.
And your answer was with the cultivator specifically, you'd say no.
Correct.
And there was no proof that Good Day Farm paid any dispensary to place the cookies display in the dispensary, right?
Regarding, I would agree with that regarding Natural Leaf and Delta, as far as we did not receive any proof of that while at those two locations. Okay.
Any other location?
Any other locations weren't, we didn't really discuss this with them at that time, as far as I know. Other agents may have, but regarding this specific investigation.
Did you ask Good Day Farm if it was advertising its products to the public?
I do not believe I discussed this with them.
And same for, did you ask Good Day Farm if it placed these displays in the dispensaries? You didn't ask that.
Correct.
Did you talk to Good Day Farms about any of the allegations in your report before issuing the violation?
I do not believe so, no.
Did you ask Cookies if it was advertising for Cookies brand products?
No, I did not.
Did you ask Cookies if it was advertising for Good Day Farm?
No, I did not.
I assume that that's a question you could have asked.
Yes, if I would have known who to contact at Cookies.
Did you ask anybody for a contact at Cookies?
No, I did not.
So no proof that Cookies place these displays at the direction of Good Day Farm? Do you have any proof of that?
That's incorrect.
Okay. And again, the displays don't identify Good Day Farm, correct?
Correct.
Again, no UIN for Good Day Farm or on the packaging. The packaging didn't have Good Day Farm's name, correct?
You mean the ones on the displays in Natural Leaf?
Yes.
Correct. I did not see any on there. Once again, I don't recall checking them back, but I do not believe there was any on there.
Okay. And the testimony is that there's at least one other cultivator at the time was growing strains for Cookies products. So you can't say that a Cookies display is advertising for Good Day Farm, right?
Just a point of order, I don't recall that being the testimony that at the time there was another cultivator who was growing the Cookies brand. I was asleep at the switch then. Now.
Agent Hodges, do you know, were there other cultivators who at that time were growing Cookie strains?
Yes, I did.
Okay. Were they?
They were growing the same strains. I don't believe they were using the same packaging or the same promotions. From my understanding, there was an agreement actually before Good Day Farm entered into the agreement with Cookies. However, I don't know for sure. I believe that there were some issues with that cultivator where they no longer want to go forward with them or something. There were some complications with that. I also saw the strains at a third cultivator or same type of strains at a third cultivator
those strains are cookies strains?
Yes, I would say so. At least they're recognized as that, from my understanding.
And would the packaging for those indicate that they're cookies strains?
And the cultivators,
Yes.
I don't think that they do not use the same packaging.
I didn't ask, do they show cookies anywhere on that package?
Once, I can't recall ever seeing those packagings, to be honest with you, but I believe they're packaged in the same way as the other strains that cultivator sells.
So you don't know if these packages show cookies anywhere on that packaging?
So let me kind of explain this. What I'm saying, when I've seen those strains there, I've seen them as plants. I've seen the plants there with those strain names.
Have you since seen them in package form for sale?
Maybe, I can't say with 100% certainty on that.
So you don't know if they show cookies on that packaging or not?
Correct.
Give me just a second. I think that's all we have.
Okay.
I want to just clear up one thing very quickly. I want to show you what is marked as page 14 of the ABC packet. This is the pictures that has the various facts of some of these packages. So when I see, pick any of these really, pink rosé, I think that is the strain. That is the name of the plant. Like you had apples, Red Delicious, that's the strain names again. Pink Rosé, that's a strain name. Apples and Bananas, that's a strain name. Collins Avenue, the soap. Those are all the strains of cannabis flower in the package. That would be packaged, right?
That's correct.
Okay. Now cookies, that's the brand. That's up here on a couple of them and maybe not on the mints, but that's a brand name, correct? That's not the strain of cannabis that's required information to be on the label, correct?
Correct.
Okay. And I asked all that question, perhaps it's intuitive, but so we're not getting too confused. If you see a strain, apples and bananas, you may or may not necessarily see a cookies brand on that flower. Is that accurate?
I would say so.
And I guess the point that I'm driving at is different cultivators may have different strains, but they're only going to have the brands that they own the rights to. Fair?
Correct.
Okay. Thank you. I just want to make sure we understood what we're talking about between strains and brands. They can be different things.
Right, but there hasn't been anything presented by either side to show that there's an exclusivity contract between cookies and Good Day Farms in this scenario. I think that testimony is kind of that there could be.
That's kind of where I'm going with this, that at the time, Agent Hodges, did any other cultivators have the cookies brand? Not talking about what strains other cultivators might have been growing, but at the time of this violation, did any other cultivator label or brand their products with the cookies brand?
Not to my knowledge, no.
Okay, that's I think all I need to know.
Okay.
So if there are packaging that was on the display, I believe it was Natural State, that were for strains that were not being sold by Good Day Farm, wouldn't that indicate that that display was not at the direction of Good Day Farm? Why would they want to advertise for strains that they weren't selling?
I believe you're making an assumption there that's not actually correct. Those strains are sold by Good Day Farm.
The fly and the fish scale?
Yes, they're just in different packaging.
why would Good Day Farm want to advertise packaging that it doesn't use?
Well, it would still be advertising those strains.
How would the public know that if they don't use the same packaging?
By looking at the strain name.
Wouldn't it be more likely that if there are packaging that is not being used by Good Day Farm, that packaging and that display and that advertising was being done by someone other than Good Day Farm?
I would say it's possible, but once again, it's referring back to those strains. Those strains are still what is sold by Good Day Farm.
I think we're just going to disagree on this, so pass the witness.
I don't have anything else for Agent Hodges. I have just a couple of quick questions for Agent Clark.
Okay. Thank you, Agent Hodges. You're dismissed. Is it Agent Smith? Clark.
Shelby Clark.
Agent Reese sworn in earlier?
Yes.
Okay.
First off.
Okay.
Go ahead, state your name for the record, please, sir.
Shelby Clark.
Agent Clark, I understood that you had gone to Prop Dispensary, taken some pictures for us, and tell the board what led you to Prop to take pictures. Why were you out there?
We were doing a inspection over at West Memphis and Dispensary Delta. And like we've heard before, we found a display in the Sally board in the driveway and delivery area that had been dropped off. It's kind of complex in the ownership. Falls owns the one over in West Memphis Delta. And a guy that works for him named Billy Finley is the permittee for the one in Jonesboro Prop. So there's a relationship between the two. So we talked to Brian Falls, which is the son of the guy that supposedly owns Delta. And he was saying that they had got this in and that they had was going to be put up in the next few days, that they sent somebody out to put them up. So after that, we talked about, he said, well, the one in Jonesboro, they'd already got it up. We hadn't saw it, I hadn't saw it. So I went to Jonesboro that day and talked to Bill Finley about it. And also those pictures that you're showing.
This is the picture, page 9 of the exhibit packet.
Yes, sir.
Okay, this is displayed at Prop.
Right.
Was there anything further from you after just confirming that the displays were there?
No, I talked to Billy about it. He said that he had a contract, exclusive contract with Good Day Farmers for the product that goes on these shelves. And that these shelves had to be put up in these stores because of the contract that they had with Good Day to do this.
Anything further from that trip to Prop? Pass witness.
So who has a contract?
Billy Finley, which is Crop Dispensary in Jonesboro. And he says it's a very lengthy, and he offered me a copy of it, and I wish I had taken it. He says it's very lengthy. You've got to buy so much of their product from Good Day Farms in order to have the displays and be able to sell the cookie products, the cookie strains.
But you didn't get a copy of that contract?
No, sir,
You didn't look at it?
no, so he had it there and he offered to show it to me and offered me a copy of it.
Any reason you didn't?
Didn't feel I would need one.
Did you ask him if he considered this display to be advertising for Good Day Farm?
Yes, sir.
I did.
And
You
he
asked him
answered,
that? What
he
did,
answered in the affirmative.
what did you ask him specifically?
Do you think that these are Good Day products, Good Day? He said, yeah, he said, we've got an exclusive contract with them.
We're not talking about the products, we're talking about the display.
Right. That he thought it was all Good Day,
The
the
display.
display. Because that's where when he signs the contract, this display was part of that contract.
You didn't ask for that contract. You don't have it to show us.
No, sir. I can get you one.
That was what, Mr. Finley told you,
Right, that's what we
not
did.
what you saw.
That's what he told me.
Thank you.
Nothing further from ABC.
You would like to have your closing statement?
Sure, thank you. Again, we would ask that this violation, these two violations be dismissed. The proof is that this is not advertising to the public. It's inside the dispensaries, it's not to the public. The public is everyone. And that's why the Amendment 98, as the Constitution is currently drafted, says that you can have restrictions on displays, which is what we're talking about here. You can have restrictions on displays that are visible to outside the dispensary. We have displays that are only viewed inside the dispensary. They are not under the rule itself. These are not advertisements to the public. They are restricted to people who have the right to be in that dispensary. I have no right, I have no ability to see that display. So that is not advertising to the public. Then even if this is advertising, I think the proof is very clear that this is advertising for cookies. It is not advertising for Good Day Farm. These displays, which again is all we're talking about, are the displays. These displays did not come from Good Day Farm. They came from cookies. And they are there by the testimony of Agent Hodges. They are there to market cookies products, not Good Day Farm. And so that is another distinction. And there's really no proof to the contrary. And finally, for the constitutional issues that we raised in the first hearing that we're adopting for this, again, this blanket prohibition on cultivator advertising is clearly unconstitutional. It violates commercial speech for any type of blanket prohibition, especially. And also, it is an equal protection and due process violation when Budweiser can have signs up, commercials up everywhere we look, including Razorback Stadium, where the official beer of Razorback football is Bud Light, that there is a blanket prohibition on advertising by a cultivator. That is clearly unconstitutional and unfair. So for that reason, we well, we would ask that these violations be dismissed.
You know, a lot of this hinges on the same type of arguments as the last hearings. I'll try not to belabor this too much. First of all, there's clearly this tie between cookies and Good Day Farm. And as I said earlier, this is advertising with an extra step. Cookies is contractually obligated to Good Day Farm. Good Day Farm is growing the strains, they're branding the strains under the Cookies logo, and then they're putting up these displays in the dispensaries. It may be Cookies is putting the displays up, and it could be that they're doing it completely without Good Day Farm knowledge. The question was posed, well, did you talk to anyone at Good Day Farm? Well, no, we didn't. And also, today is Good Day Farm's opportunity to defend themselves, and you'll note there is no one from Good Day Farm here to refute any of these charges or claim that they had no idea that Cookies was putting up these displays. So while it is our burden of proof, I think we have met that on a prima facie basis at least, and to say that there were extra steps that should have been taken by enforcement, there's extra steps that should have been taken by investigators. I can tell you, there's plenty of times where you would like to see more steps or different things done. Ultimately, they're the party that represents Good Day, and Good Day Farm has elected not to appear and present any evidence or testimony before this board. So I don't agree with the assertion that there's not been a tie to Good Day Farm and Cookies. This is advertising from the alcohol world. We have rules that this board has seen before, where we have wholesalers putting up displays in liquor stores. There's restrictions and limitations. We don't ever, worry too much about, well, is it really viewable to the public, and therefore is that a public display, is that advertising or not? Because it clearly is, and we all know it clearly is. The fact that the general public, that anybody can't walk into a dispensary, doesn't make patients, children, caregivers, contractors, it doesn't make them less of the public. There's plenty of members of the public that can't enter a dispensary. There's plenty of members of the public that can't enter other places as well, and that doesn't make it less open to the public, advertising to the public. And when you look at the context, it clearly says the cultivators may advertise to the dispensaries. If the idea was, well, the cultivators can advertise within a dispensary, then that's what the rule clearly would have said, right? If cultivators, the idea behind this rule was cultivators can't advertise to the public, but you can put up advertising within a dispensary. The rule clearly would have said that. And that's not what it says, because that was not the intention. The intention was cultivators don't advertise to the public. So without trying not to belabor the same points again, we'd ask the board to affirm the director's decision.
The one thing I would add again, this is the burden is on the state, not on Good Day Farm. They don't have to show up with proof. The burden of proof is on the state, and they've not met that burden. I will also say and object to any testimony about what someone else said. That's clearly hearsay. So would object to that as well.
The proof before you is that Good Day Farm has their label on all of the Cookies products. And there's no counter indication that anyone other than Good Day Farm is manufacturing them.
That's completely not supported by the proof. There's testimony that other cultivators are growing cookie strains of product.
The idea that they are growing, that's why I took a minute to say strain and brand are two different things. If someone else is growing fish scales, that doesn't necessarily mean there's a branding agreement with Cookies. And there's nothing that would indicate anyone other than Cookies, Good Day Farm, are on the labels together. So I would disagree that ABC has met prima facie burden of proof here, and it has not been reviewed by Good Day Farms.
Any further? Thank you for all your testimony. I think at the board's pleasure right now, we kind of have two challenges in front of us. One is, at the end of the day, Mr. Lancaster we're here not to write the laws, we're here to enforce the laws, and while we might not agree with how some of them are written, or we're limited to what's in front of us here today. And it sounds like things are being done to address the changing environment we are in at this point in time, and continuing to change. I think the first thing for the board's kind of just, decision is really what it comes down to is, from a rule perspective, how does the board determine public? I think that there's a valid argument made both ways on what is public and what's not. Personally, I would agree with either way, saying that it is restricted to those, it is a limited public restriction, but it is people that, fall under public. And then the other challenge is, to what level of degree we have with Cookies and Good Day Farm. I mean, it's evident that you can see in, page 15 of the report from the respondents that the products are coming, out of state to these groups, so you can't, to some degree, you can't argue that, Good Day Farms is having stuff sent, Cookies is sending stuff out to people outside of it going directly through Good Day Farms, but also there's an argument, as Commissioner Anderson said in the last hearing, there's got to be an agreement and a contract in place, and while we don't have that contract in front of us, I'm assuming there's some assumption that they're working in conjunction with each other, that they're responsibility of what they're doing on behalf of each other. I'm not trying to argue contract law, and we don't have a contract in front of us, but it's, we got two challenges we have to kind of, if either one of those goes towards, it's outside of Good Day's responsibility, that kind of poses a challenge for us to affirm the director's decision, but I think a very good argument's been made by the ABC at this point as well. So with that, is there a motion at this point?
Well, I thought you was going to continue with the motion.
No, I don't think I can do a motion.
Yes, you can.
I can, that's correct.
Yeah, you can.
Is there any?
Don't back out.
Is there, well, I was just kind of putting out like an opinion for the board. Is there any other opinion before a motion is brought forward? Commissioner Smith or Anderson or Ms. Bam? Amy, you're usually not short on words.
Trying to give somebody else a chance to speak.
Motion.
If there's not an opinion,
If you change and vote differently on this one than you did on the first one, it's almost like we're hitting on both sides of the fence. It's the same issue both ways.
well, I think the argument on the public side is that the bus was outside of the building. And it was clearly visible from the public. The argument they're making is the packaging is, the sign is inside the building, and does that constitute public or not? That's the big thing that I kind of see with the differentiation between the two.
In my opinion, the public is considered to be everyone, so anyone who goes in that building is considered to be the public. And I think according to the law, what they were trying to do is to have no advertising, because you didn't know who was gonna see it. We allow children to go in there, and it's just my opinion that there should be no advertising within the dispensary.
As the law is written right now.
Yes.
I believe that was the way it was intended. It's almost as if, in a way, it's trying to be portrayed that word cookies and the logo with advertising in one case and not the other. regardless of where it's placed. Sure, one was placed outside of the building, and one inside the building, another. I don't see any clothing hanging off these shelves. So it's back to what Steve said, these are separate cases, separate hearings. But with much the same evidence.
I think if you rule it differently, you're just showing inconsistency in your rule.
We were asked to consider the same testimony in this one that we did in the previous one. You can speak out of both sides of our mouths. They tried to portray that there's no control, yet Agent Clark said that Agent Goodday was informed this is how it's supposed to be in contract. We're here because everybody wants to walk a fine line, walk the top of the fence, knowing that just over it's illegal, just this side is not. Here, everybody wants to push what's written, reinterpret it. We've been operating under a pretty consistent way in what we've done since all this came about. The wording hasn't changed. If the wording changes, certainly soon we're going to change how we
Until that happens, we can't do it different. The intent is still the same intent. Pam, get after it.
Do you want me to make a motion?
I just feel like we need, just like we ruled that whether or not Dorothy should testify. I think we need to stay consistent for lots of reasons until something in the wording changes or we're convinced otherwise.
So just from a point of clarification from a legal perspective on how a ruling would be presented here today, or a motion presented. If the board votes to uphold the director's decision, then as part of that, would there need to be something in there about what to do with the signage in these buildings?
If the board's determination is that, yes, this is an advertising violation by cultivators, there would not necessarily need to be a decision made about what to do with all of these displays moving forward in the future. Depending on what is worked out between administration and Good Day Farm, may well be, if the director's decision is upheld, that this would go up on appeal. And I think it's likely that we would not, rush to take action on every single display that we see until there is resolution. That is something that I think, hesitate speaking for another attorney, but I think everyone would agree. We'd like to have a very clear resolution, whether ABC administration is correct in its interpretation, Farm is correct in their interpretation. And so long walk to say, there wouldn't be a need for the board to be too concerned about what happens outside of today's hearing, today's case. What we do moving forward is likely to be, we will get clarification. If it's not appealed, then, or if there is an appeal that goes ABC's way, then we will take steps to make sure this is enforced the same way in every single facility. In the interim, probably just be waiting for a decision, and if the decision comes back our way, then there'll probably be violations that go out, but we're not interested in trying to get violations on an issue where we understand there's a good faith legal basis for dispute here. So, I'm sorry, does that answer what?
Yeah, I mean,
What you're telling me more is it's not clear.
Well, this is informal. We are yes, there's a burden of proof that may or may not need to be ratified, but if I'm clearly innocent on something, I'm gonna show up and testify. If I'm walking the line and I might get shot down, yeah, it's probably in my best interest not to show up. I have a problem with them not showing up. To say, no, there's not a contract. Yes, there is a contract. Yes, I'm told what I can display, what I have to display, how it looks. Can I put somebody else's product on that display? Everybody knows no lawyer, but I have a problem with that. Don't show up and don't send somebody to show up and say I'm innocent. I'll show up and tell you I'm innocent. Here's the proof.
So to kind of further go into the track what you're saying, I think it needs to be well documented on this. If we uphold the director's decision and in a hypothetical it was to be like appealed to the circuit court, that would be the next step. In the interim, could a dispensary having product on their shelves be able, like, are they running the risk of using that shelving in the interim if the circuit court was to uphold the director's?
Yeah, strictly speaking, yes, there's a risk in the interim if the director's decision is upheld, that in the interim, the dispensary has these shelves, these displays, that Good Day Farm could get another violation. We're not particularly interested in doing that because they have an argument, and I understand their argument. It's already been raised, and it's already, as I mentioned in the previous case, it's already gone up to the circuit court. So there is an argument to make. What would happen to Good Day Farm if there was more displays within more dispensaries? I can't answer that right now. It could be a matter of we hold off on issuing violations until we get an order. If it affirms us, then there might be a whole bunch of violations that go out all at once. I hadn't considered the prospect of what we might do in the interim while we're waiting for a circuit court or appellate court to give us a decision.
I would just think that I'd recommend as a person in the ABC that needs to probably be a good message to get out to everyone, just to make sure everyone's on the same page.
Sure, and that would be our preference is to ask people to hold off putting these displays up until, again, if the board does affirm the director's decision, to essentially have this done by stipulation or agreement, hey, tell all these dispensaries don't put up these displays until we have either change of law or clear outcome. And even if there was a display, we don't want to go through all this all over again just to find out 3, 6, 10 months from now that this decision will be going a different way. So we're not trying to duplicate anyone's efforts.
Okay, so I can say that they were in violation, but I don't know how much of this $12,500 goes to that fine, and say that at this time, we will not impose a fine or penalty on the displays.
Yeah, that would be $2,000 based on our, how we've done these
Fine for the displays, 2,000, the
total.
the 10,500 for the 42 counts of improper labeling.
Yes, sir.
So just speaking, I'm just thinking that we say it's a violation, that I'm not going to impose a $2,000 fine for this because I'm not totally convinced it's all that clear. Is that still, I'm still straddling the line on the deal, so I just don't know.
Well, I think we have to make a statement one way or another. Are we straddling the line by the wording in the marijuana rules we're given, or are we not?
Right.
We've got a track record so far.
So our track record is we don't want any displays in the,
There's been rulings on these that haven't come to a hearing. Am I correct?
There have been other violations for cultivators placing what we deem to be displays or marketing that was designed to market it to
They paid a fine and did
Public,
not
yeah.
appeal it.
They didn't involve cookies.
That is also true.
There have been,
This has been a consistent within ABC administration and enforcement. When we see something that came from a cultivator into a dispensary that wasn't marketed solely to the dispensary, that part is allowed. But a display, that becomes, okay, this is intended to be displayed inside the dispensary for the public. That we have held is advertising.
Signage.
So one other question with this too, because it is potential from what we've heard that there might be some new legislation coming through in regards to cleaning up some of this advertising stuff. If the legislation, which is always subject to change, has not been voted on or ratified by the state, from your understanding, if something was to pass with that, with cleaning that up, could it be done in a way that like it would be retroactive, or would it be like moving forward? So what I'm getting at is we uphold the director's decision, this new legislation at the legislative assembly right now goes through, then it would make this like a moot point that,
you get a speeding ticket today and tomorrow they raise the speed limit on that same road, you don't get your money back.
yeah, that's fair.
It's pretty unlikely, typically, as Chairman Anderson said, yeah, if there's a violation and then the law changes, it's still a violation under the old law. There are some times where it might be a change, it might say effective date of this will be something other than, I wouldn't expect to see something like that. I would expect to see, at most an emergency clause that makes it effective sooner, but if it does change, whether or not this matter is a violation, then change it and we'll deal with it when we get there. But now we're kind of getting ahead of ourselves.
Yeah, I know.
Yeah, we're spending a lot of time on what is the future.
Okay, well, anyone like to make a motion? If you're thinking about reducing the fine.
I don't want to open another bag of worms and be consistent with what we've done in the past, or what's been done by ABC in the past. I'm sure all this is coming for us.
Staring at me.
Okay, fellow board members, at this time with the information in front of us and the rules in their current state, I make a motion that we uphold the director's decision in regards to Regina M. Thurman Good Day Farms located at 3300 North Hutchinson, Pine Bluff, medical marijuana cultivation, appealing the violation in regards to facility advertised or marketed products to the public, 2 counts. And at this point, they're upholding or they're not contesting the second charge with 42 counts. So with that in mind, I recommend we uphold the director's decision and the fine that's currently in place.
I'll second that.
All in favor?
Aye.
Aye. Thank you for your time.
Thank you.
Thank you.
Appreciate it. At this point, I'd like to adjourn the meeting. Thank you for everyone.
Yeah.
Thank you for your patience. I really appreciate it.